Welcome to the Business SOS podcast. This is Rich Sierra, President of the Florida Small Business Legal Center. This is episode 94 of the Business SOS podcast. I'm very excited as we only 6 episodes away of episode 100. I'm very excited about that. Thanks for listening, joining me today. Today, I'm going to dedicate this show to the graduating class of the Chapman School of Seamanship. They're located in Stuart, Florida. They teach marine surveying class, and my friend George Seidler, he's a program director. He invites me like 3 or 4 times a year when they have a graduating class to speak to the new graduates about things to avoid or what to expect in their new career as marine surveyors, as many of them open their own businesses. So what I'm going to do today is do that presentation. Sometimes I cannot make it to the day that he invites me to because I have a deposition or trial. And in fact, this week, I'm not going to be able to make it next week. So I want to make it up to them by having this show dedicated to them, and as well go through the presentation so they can show this video to them in the case I cannot make it to the class. Today's episode is 8 legal mistakes to avoid when starting your business. This also applies whether you have starting a business, also whether you have one now, because the mistakes can be avoided and you will be facing many legal issues along the way in your business journey. So the mistakes are actually follow the format of my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them, which I published it about 2 years ago. And it's available on Amazon, Barnes & Noble. You cannot ask for your local bookstores as well. So I followed those basically chapter by chapter. So I'm going to go through them and talk a little bit about them. So mistake number 1 is that business owners make, whether new business owners or experienced business owners, is not hiring a lawyer to save money. And I see that often, and the consequences and sometimes are devastating. And picture this. You're starting a business, you're opening your corporation, you go to SumBiz or LegalZoom, it's fairly easy to create a corporation. You invest in business cards, you create a logo, you maybe get an office, maybe you work from home, but you buy some computer equipment. You're already invested in all this, infrastructure, so to speak, but also you create some contracts. Especially in this particular case, we're going to focus on the people who provide services, like marine surveyors. They will have a service contract. So, and you go into Rocket Matter, and again, I'm not a Rocket Lawyer or any LegalZoom or any of these places that provide some online contracts, and you download it from there as well. And as I said before, many of the contracts that you download from the web, they're not terrible. I mean, I've seen many of them coming in, and they usually have good standard boilerplate provisions. What many of them lack, because they just cannot have it, is items specifically to your situation. So downloading something from the web, and I'm going to go over that in more detail shortly, it gives you a good start, but it doesn't mean that will be helpful to you in your particular situation. And what happened is that by the time that you've learned about the mistake, when it's too late, when something happens that you did not anticipate because you did that you did that contract on your own, decided to save money in attorney's fees, and not have an attorney draft that contract for you. Sometimes consulting with a lawyer might cost you maybe a few $100s. Drafting a contract, maybe $1,000 or a few $1,000s. But if you're going to be using that contract every single time, and you're expected to make hundreds of thousands of dollars or even more from that contract, it might be a good idea to perhaps have an attorney prepared for you. And think about this. Everything that you do in your business has a legal implication. Everything that we do. So if you want to reduce expenses, if you want to cut corners, I believe that's not the area that you want to reduce your expenses on. Because the idea of the attorneys to really provide some protection, some safeguards. So in the event that you run into some type of legal dispute or legal landmine, you are prepared for it. So again, that's legal mistake number one, not hiring a lawyer to save money. The legal mistake number two, and it happens very often, is signing a contract without an attorney reviewing it. And you get the theme. A business lawyer can be very helpful to your business and to your business journey, just as an accountant as well. You need to have, I think, those two safeguards: an attorney, an accountant. Also, you have a third prong, which is the insurance component as well, to have you give you the proper protection as you go forward with your business. You have less things to worry about. And not all contracts are created equal. In business, the contracts can vary. There's just so many different variations of the contracts because the terms are different and business owners are creative. So we might come up with different terms, different options, different payments. So to utilize a boilerplate contract that you download from the web for your business without an attorney reviewing it and making sure that those provisions are protect you is a significant mistake. But likewise, having a contract that is sent to you that you do not understand, just because it's formatted well, has nice words there, doesn't mean that the contract might be good for you or for your business or for your benefit. Whether the contract has a personal guarantee, you need to understand each and every provision of that contract. And if you heard this podcast before, you know my rule. If you do not understand the contract, do not sign it. Just ask questions. Many business owners, and my clients that I've encountered in the last 20 years of my career, when they present a contract to me, a contract dispute, and I look at it and I said, well, do you understand this contract? No, it looked good. The other attorney told me that it was good, the attorney from the other side. I'm like, well, that's not the way it works. The attorney from the other side is representing you, representing the other side's interest. Or I gave it to a friend to review, and he told me that it was fine. Okay? It is your responsibility as a business owner to understand your contracts. The courts are not going to invalidate a contract because it's not a good deal. If you decide to enter into a bad contract, the court will enforce it. So you need to be clear of that. The court is not going to babysit you or make sure that the contract is fair. If you decide to enter into a bad contract, you're on your own. There's some exceptions to invalidating a contract, and perhaps I should do that in a separate episode, in ways a contract can be invalidated. But that is the subject of a different topic. I would talk about duress, lack of mental capacity, their, fair bargaining power. But that's not what we're talking about here. We're talking about here, you run-of-the-mill transaction that one party promises to do something, the other party agrees, there's going to be a payment, and then you sign it. So if you have any questions about a contract that is presented to you, you're better off having an attorney review it and giving you advice, at least for you to understand it. If you still decide to enter into the contract for whatever reason, at least you understand what you're getting into. And that's really my role here, is to advise you. Whether it's a good deal or a bad deal, it changes in every circumstance. Sometimes you're better off getting into a bad deal in the short term because it fits your circumstances at the moment. But the very key here is for you to understand what you're signing. That's where a business attorney comes into play. Mistake number 3. defending a lawsuit without an attorney. So I've gone over this before on prior podcasts. Let me touch upon that again because it's important to mention it. If you are an LLC or a corporation, a business entity, and you get sued anything above small claims in Florida, you will need an attorney to represent you in court. Let me repeat. If you're an LLC, corporation, a business entity, and you get sued, you will need an attorney to represent you in court. So the only exception is small claims, which in Florida are claims up to $8,000. If you get sued for, say, $5,000 from a customer or a vendor, you don't need an attorney to represent you in small claims. Although it's advisable, you technically do not need one for that. Now, what I see happening here is that a corporate entity with small business owners, for the most part, they're LLC or corporations, be a single member LLC, or there's one person that owns the company. The corporation is technically a separate legal entity. Gets sued, they get upset, rightly so. Usually when you get a lawsuit, there's there are no flattering comments made in the lawsuit. Things that will make you upset. And many of them could be misrepresentation or things that are not true. So in that anger, in that haste, the business owner decides to immediately write a letter to the court explaining everything that happened in that circumstance and go ahead and start attaching documents, in essence, trying the case in that particular letter. Sends it to the court. The other side, especially when there's an attorney on the other side, will look at it and say, well, thanks for all this information, but I'm going to move to strike all the pleadings because all those pleadings will be stricken because they were not submitted by an attorney on behalf of the company. But you provided all that information to the other side, which you did not have to provide. When the pleadings are stricken, the court usually gives you, say, 30 days to find another attorney who will dismiss the case. Or will basically file a final judgment against your company. That's when I get involved. That's when I usually get the call and say, hey, I filed this letter to the court. The court did not accept it. They gave me 30 days to get an attorney, and I usually get the call within 10 days or less. Clearly, there are things that we can do to get rid of the emergency, motions to extension of time, so file notice of appearance, the things we can do to kind of neutralize the emergency so we can begin working the case. But then what happens is that when I look at the information that has been provided to the opposing side, my question is, why did you send this information to the other side? Why do you file this with the court? And the answer is, well, I wanted to explain everything to the judge. Well, the judge has like 3,000 cases. They're not reading your material when you're sending it to the court. The only time the judge reads something is when there's a hearing or we're going to go to trial. But other than that, it goes into this online filing system that nobody reads. So it's a mistake that is made. And by sending that material ahead, what happens is that you might be making some admissions that you didn't have to make in the first place, or perhaps you volunteering documents that you don't have to provide, or at the very least not at that time. I'll give you a perfect example of what happened in a case that I had recently. So we sued this individual for close to $250,000. There was a loan that was made, and he just didn't pay the loan. Sued the corporation and the individual. So this individual, the defendant, did not get an attorney. What he decided to do is to write a letter to the court, explaining the situation, and writing, yes, I do not owe him $250,000. I owe him $220,000. I intend to pay him. That's what he wrote. That was done on behalf of the company, on behalf of the individual. Me, as plaintiff counsel, but I did okay perfectly. He just confessed to the judgment. Simple. Subsequently, we filed a motion to strike the pleadings as far as the corporation is concerned, and a motion for summary judgment against the individual because she already confessed. She already said, I owe the money. $221,000, $20,000, fine. We'll just ask for summary judgment, $220,000. The court granted the motion because he confessed. And he also got it notarized. So he could have gotten an attorney. Things could have been differently in that case. Presented defenses, but he did not. So just to give you an example by never sending a letter to the court. And one more point I want to make about this is that the standard that you're held, and it's not a fair standard, if you are representing yourself pro se or, individually in a court, you'll be held to the same standard as if you were an attorney. It's not a fair standard. So if you have an attorney on the side who's being represented and you're not, you are at a complete disadvantage. You're not going to prevail even if you have if you have your case is right. You do not know the rules. They do. So getting an attorney is essential if you have a lawsuit against you and you have an attorney on the other side. Mistake number 4, signing a commercial lease without understanding it and also without having an attorney review it. You get the theme. An attorney should be involved in every aspect of these transactions or these items. Commercial leases, especially if you're going to open your business and you're going to have a lease, is important. Most of them do. Unless the business owner owns the building, which is rare. For the most part, the business owner is going to work from a office location or a storefront or some type of, or at home. But we're talking here about storefront or a warehouse or something you have to take on a lease from a landlord. And commercial leases are very different from residential leases. In a residential lease, usually have some standard forms that are required by the government. I don't do residential leases, but I've seen them, so I'm not going to touch upon that. But a commercial lease is different. They have some common themes. However, they have some very different variations, and they are different. There's not one commercial lease that is the same for everyone. So what happens is this: the business owner is excited. They want to start the business. They see a storefront, or they go to an office building or a warehouse. They have a property manager. They give them this packet and say it's a lease. They give them a proposal, kind of a term sheet. They look at it and say, okay, let's go for it. They sign it. 3 years, $2,100. They don't do any inspections, and I'm using that as an example. Okay. And they then find out that in the top of the lease, they have taxes, insurance. They got to pay real estate taxes. They get a bigger bill than they expected initially. And they find out, well, I didn't know about these. Send the lease. Or worse, what happened is that they cannot support the lease. That's when I come in. When they go ahead and find out that they're not making enough money to pay that lease, and they get an evictions notice, and they also get a lawsuit for the balance of the entire lease, which could be, depending on the amount, over $100,000, 60, whatever the case may be, but for the balance of the entire lease on breach of contract. And I said, what happened here? And I said, well, I got into a lease. I thought it was $2,500 a month. It ended up being $3,500 a month with all the taxes and insurance and maintenance. You say, do you know that? No, I was not aware of it. So, but it's in the lease. Usually my follow-up question is, did anyone help you review this lease? No, I did it on my own. Well, I had a friend help me. Or the property manager told me not to worry about it. Or the real estate agent that was helping me told me it's all standard, it looks good. a real estate agent is going to get a commission. In this particular case, the client did not have anybody representing him or helping him understand the provisions. And I have podcasts that go deeper into lease agreements. Another situation that happens with leases is that there's usually a maintenance component that the tenant is responsible for certain items in the unit. The big one is the air conditioning unit or the heating unit, HVAC. And I usually recommend to my clients, before you sign that lease, get somebody to inspect the unit. Get someone to inspect everything you're responsible for to make sure that it's going to be operating during the term of the lease. Find out how long the unit is, how old the unit is. So if the unit is not going to make it through your term of the lease, you got to negotiate replacing that unit or capping their repairs at a certain point. You have to do that before you sign the lease, not after. So a commercial lease taken very seriously because they could be very expensive for you. Mistake number 5 is lack of understanding how the business is going to generate revenue. You'll be surprised the number of people say, I want to start a business. And I say, okay, tell me more about it. And, it could be some type of restaurant, ice cream shop. And I usually use the ice cream shop example in my book. And I said, what are your operating expenses? Do you have a business plan? The answer is no. Have ever you been in this business before? The answer is no. So before going into business, A, do a business plan. B, if you do not know how to do one, I do recommend people go to SCORE. And this is a free service that they provide with retired executives that help you do a business plan. It's a free service. Many universities have like a business type program that have students help you prepare the business plan. Understanding how the business is going to generate revenue, have projected expenses, what is going to be your profit, cash flow requirements is essential. The reason for that is that if you don't have that in place, the lack of cash flow, it's not going to help. You're not going to be able to pay your bills, and it's going to inevitably lead to legal expenses, legal disputes. So when I talk about, ask the potential client, ask what is your break-even point, they're not sure. How many sales do you have to make to pay all your expenses? They do not know. So it's important for you to know that in advance. Work projections. It's not going to be a perfect science, but there are tools available on the web that can help you that. There are consultants as well. Mistake number 6, going to friends with or family, going into business with friends or family without a partnership agreement. That happens very often, usually after the holidays. People get together, they have great ideas, nothing wrong with that. They want to go into business. Usually somebody's a technician, somebody has the money. They want to buy, they want to flip homes, and they say, I'll have the money, I'll go ahead and give you the money to buy this property. You fix it, we'll sell it, we'll make the money, we'll split the profits. Great business. I know some friends that are involved in that, very successful. But what happens is this, is that when you don't have those agreements in place in writing, situations will happen that then later on disagreements will take place, and then you have nothing to understand the nature of what was agreed upon in the first place because it was not in writing. It is important that whatever agreement you make with another person has to be in writing or entity. Okay? So that's usually what I recommend. Mistake number 7, lack of understanding of basic contract law. It is important for you to understand when you have actually entered into a contract. And, we have this formula, offer, acceptance, consideration. That's what it teaches in law school in the first in Contract 101. But there are a lot of nuances to contracts. And I'm not going to go into a whole class about contract law here. But the point is this. One of the things that I see happening is that people want to go into business, they have this email they send out, this text message send out. Yeah, let's go ahead and do this. Go ahead and buy this property. And somebody says, I'll let you know. Or let's buy, we'll figure out the rest later. So they're really not, the terms are undefined. And I've seen contracts that said, okay, we will figure out this term later on. There's circumstances that might take place. Okay, but I don't like undefined terms in a contract, because someone can argue you really did not have a contract because it was strictly an offer. So understand with that when you actually have a contract. And going into the contracts as well, if you have a contract that you sign electronically, make sure you get a copy of that. Oftentimes I get, in breach of contract claims, a contract that was signed via DocuSign but only one person signed it, or a draft. It's important that you have a copy of a fully executed contract in the case you have to enforce it or defend it. Mistake number 8, this is the last one. Staying in a lawsuit on the basis of principle. This happens more often than you realize. Lawsuits are very personal, they're very emotional. The things that are said about you that are not flattering, they're usually inflammatory, and they will get it under your skin. And I've heard this term before, I'd rather pay you than pay him. That usually does not work out, and I don't recommend it. Simply because the objective, when a lawsuit is filed against you, the objective is to get out of it as fast and efficiently as possible. And when a lawsuit, you stay in a lawsuit on the basis of principle, you're not thinking rationally anymore. You're continuing a litigation because you want to prove a point, when the lawsuit is basically suing for money. And it's good to discuss with your attorney, what is your objective with the lawsuit? Why are you staying in the lawsuit? And sometimes a bad deal is better than staying in the lawsuit in the long term in the first place. Lawsuits are unpredictable. No one can guarantee what's going to happen in a lawsuit. And when you're going to a lawsuit, in essence, we're telling the court, the parties cannot resolve the dispute themselves. So we're asking the court to resolve it for us. And the court will resolve it for you. You might not like it the way it's going to get resolved, but the court is going to make a decision, and there'll be a winner, there'll be a loser. And there might be an appeal. And if you heard me before, I'm a big proponent of mediation and alternative dispute resolution to allow the parties the opportunity to resolve the matter in a confidential way, but also on your own terms, to really push that as hard as possible to, number one, provide closure to the dispute. Number two, keep it in a confidential manner. And number three, reduce legal expenses, as opposed to continuing perpetuating a lawsuit that can go between 18 to 24 months with no guarantees how it's going to be resolved at the end. Now, if you're defending the lawsuit, that's a different story. You have to defend the lawsuit, and there's a decision you got to make. How much do I have to pay? What's going to cost me to pay to resolve this matter versus how much it's going to cost me to defend it? And the answer is not that simple. So that's where discussion comes in with your attorney about the cost-benefit analysis of resolving it versus continuing. And sometimes you do not have a choice but to continue it because the other side does not want to move. That's understandable, but every case, you got to look at every situation on a case-by-case basis. So just to recap some of the items we covered this morning, or afternoon, depending what time you're listening to us. I record it in the mornings. The mistake number one, not hiring a lawyer to save legal expenses, save money. Number two, signing a contract without an attorney. Mistake number 3, defending a lawsuit without an attorney. Mistake number 4, signing a commercial lease without understanding it and also without an attorney. Mistake number 5, lack of understanding how the business is going to generate revenue. That would talk about having a business plan. Mistake number 6, going into business with friends or family without a partnership agreement. Mistake number 7, lack of understanding of basic contract law. And mistake number 8, staying in a lawsuit on the basis of principle. Again, I want to thank again the students at the Chapman School of Seamanship for inviting me, and my friend George Seitler for inviting me to every time they have a graduate class to go and speak with them, and I hope that I can go there as often as I can. I really enjoy sharing my knowledge and my experience with them and really getting those questions from business owners that are about to start. Those are really exciting questions, and I love to see that happening when people are eager to start a business. It's a very great passion to have. And I certainly want to wish them the very best of luck. And I'm always available if they need me. If you want to contact me, the best way to reach me is rich@richsierra.com. Again, it's rich@richsierra.com. My phone number is 866-842-5202. My website is floridasmallbusinesslegalcenter.com. If you want to get a copy of my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them, it's available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. Until next week. One more thing. If you like the podcast, follow us. Hope you give us a review. Share with your friends. We're available in Amazon, we're available on Apple Podcast, Spotify, wherever you enjoy your shows. Also, if you want to see the video of this podcast, we're youtube.com/@RichardSierra. Until next week, this is Rich Sierra with the Florida Small Business Legal Center. And remember that my goal is to help you succeed.